I kind of wanted to touch on quickly. One thing I noticed in the Biden executive order was that they said they want to specifically craft their regulations around what other countries have done in the past, kind of around cryptocurrencies, because this is going to be a tough thing to have completely different playing fields in every single jurisdiction. Do you think that is a good sign for essentially Congress stepping in and saying, look, if all these other jurisdictions have already said these things are not securities, how does it make sense to have a completely different designation here in the US?
Well, it depends. So that's in the executive order for Biden. He is, there's a presidential election in the US in 2024. So I think the executive order was maybe 6 months. They were supposed to do something. It's not like a hardcore law, quote unquote, an executive order. So, if they were behind, they could just be like, hey, give us another, 3 months to do this. So, by the time that the report comes out, because it's nothing definitive, it's just supposed to be a report. We could get into election season, nothing's going to happen. A new administration, new political party comes to power, and, they're just like, forget that executive order. We're going to start from scratch. So, it's nice that it's in there. It's nice for XRP because so many other countries say it's not a security. It could be bad for Bitcoin and proof of work things because now there is a push on the, whether you agree or not, green energy, Green New Deal, global climate change. There's a push in other countries in the EU to ban proof of work. So, that could make its way into US legislation. If everybody starts banning proof of work internationally, that could really hurt proof of work coins like Bitcoin. So if it does go the international route, it's favorable for XRP. It could be unfavorable for proof of work since that's kind of happening. I do think they'll take it into account what Congress will eventually take into account what other countries are doing. But I think at the end of the day, the executive order, it's just, baseline foundational stuff of what are we thinking about, this, that, the other, nothing's definitive yet. It doesn't get definitive until you start seeing Congress hash things out in the committee and what they're going to do and what they're going to put in there.
Cool. Yeah, no, that makes sense. I mean, that's kind of where I was. I thought at least it was a good sign because the SEC has kind of come at this with the assumption that, hey, this is obviously and clearly our jurisdiction. I think this is kind of a slap in the face to that. Like, your own administration is telling you, like, this isn't clear. Like, all these other jurisdictions are saying this is not how we're going to do it. So why do you think that would change specifically in the US? And I see big problems being presented there because, I mean, you can get around securities laws in the US with a VPN now based on how the SEC wants to regulate this. Because if you just change your VPN to somewhere outside the US, then suddenly you don't have to abide by the securities laws. So I see that being a big issue. It seems like to me when they brought this case, they didn't hash out a lot of the details that are going to present big issues for them later. And I even think about the judge potentially ruling on the status of XRP. I mean, exchanges don't even have clarity on if they can, or traditional exchanges don't even have clarity on if they could list crypto assets. So, I mean, how could she make a decision on the status of XRP and then it would essentially just be like, all right, well, now it trades nowhere in the US? I mean, it's almost front running other decisions that seem like they have to be put in place beforehand. Seems like the judge would have to go into that understanding like, hey, I'm about to nuke a bunch of XRP holders in the US. And I think it's pretty obvious she understands there's a lot of attention from the retail side following this case.
Oh, yeah. I mean, again, it is unprecedented, the motion to intervene from John Deaton. I mean, that just has never happened before, that type of intervention motion in this type of securities case. So judge is well aware of it, which is awesome. I think she totally gets, Judge Torres and Judge Netburn totally get the fact of the implications here. And if you think about it, if there is a loss for Ripple and XRP's, is deemed a security, I mean, it opens the floodgates of litigation for plaintiffs' attorneys, like me, like the plaintiffs' attorneys in the Ripple civil case in Oakland. And I want to give all the listeners a heads up on that one. because, plaintiff attorneys, what I do say in my medical malpractice cases is I work on a contingency fee. So, with this huge Ripple civil litigation and, when two companies fight each other, they hire big time attorneys and they pay them by the hour. I bet the Ripple attorneys, the top level partners, charge $1,500 to $2,000 an hour for their time. Even the low level people, I bet, charge $500 an hour. When someone gets crushed by malpractice, it's, everyday people like you and me that they can't afford that. So a plaintiff's attorney says, all right, we'll advance all the costs of litigation, could be tens of thousands or $100,000. And if we, get a jury award, you'll give us a third of that, 33%. So it's high stakes, high risk, high reward for people, for plaintiffs' lawyers. So if XRP is deemed a security, then one of the things that I would want to do right after that is I would want to sue Consensus, the Ethereum Alliance. I would want to sue all of those people for doing unregistered securities, because I already know they've got billions and billions of dollars. And if I've got this Ripple case saying it's a security, and I've got the SEC saying, under oath, oh no, we never made a determination on Ethereum. Well, then boom, I'm going to bring this, to the court, and I'm going to let this roll out in court and see what's going to happen there. Because how can XRP be a security and not Ethereum based on what a judge in, Southern District of New York ruled? Again, if Ripple loses, I don't think it's going to happen, but
there's no logical explanation on why XRP would be a security and why Ethereum wouldn't be. And I think we saw the SEC kind of panic on this very early on when they were originally trying to define Hinman's emails and the speech in general, because I think they were terrified to have to go into this litigation and try to present some kind of comparison on why they think Ethereum was all set and XRP wasn't. And I think that's something they would have got themselves into if they did go with the declaration that Ethereum was declared not a security by the SEC, because that's an impossible argument to make. Everything they have put out there publicly makes XRP look significantly less like a security than Ethereum. Even going back to the funding thing, I mean, I've seen Bill Hinman say multiple times, fund your company with VC money, come out later, issue the token, and don't use the token to raise money for the blockchain. This is exactly what Ripple did, perfectly in line with the SEC's guidance. They get sued, and then Ethereum does the complete opposite of what the SEC said to do, and they get the free pass. So this is clearly a big issue on that distinction. But back to what you were saying with the lawsuit against Consensus, from what I understand, that would be a much easier lawsuit to make rather than against a government agency, because from my very little understanding, I think there's a lot less privilege and immunity going on there. Is that correct?
Yeah, exactly. So, that is, there's two huge obstacles to the class action that John Deaton's going to do and the one I'm trying to do against Clayton and Hinman, which is, you sue the SEC, you sue any governmental entity, the government allows you to sue it, but it also makes it very difficult. And so that's, the lawsuit against the SEC is a huge hurdle, because there's also a big case when somebody tried to sue the SEC for Madoff. I forget the opinion, but there's a line in there where the court says, as egregious as the SEC's actions were, as much as they failed, as terrible as they were, the plaintiffs cannot bring this claim because of governmental immunity.
Okay.
And I actually think, but John's got a better shot because I did go into that case. The facts are a little bit different, and he's got a chance. My case against Clayton and Hinman also has a lot of obstacles, because, if the court were to hold, hey, I know you're suing them personal capacity, but they actually were working under the SEC, so it's a government claim, then boom, it's over with there. And then lastly, as an aside, damages are for both of those cases if SEC loses, because everybody's probably still holding on to their XRP from before the lawsuit. And if XRP goes to like $4, $5, $6, well, then how were you really hurt by the SEC lawsuit? Because you held the whole time, and now you've got 10 times the money that you had originally. So what are your damages in the lawsuit? So that's those are factors there too. But yeah, if it goes bad for XRP, the civil case against Consensus, any VC company
What
that
about like
has
Simpson Thatcher or someone like that?
that one would be a little difficult because they were just clients. They were
Okay.
Ethereum-based clients, so they're kind of like an intermediary. So they're not actually, holding or selling. I mean, they could be. Who knows what's actually
Yeah,
happening?
right.
But like,
It's hard to even make any speculation even on that. I would not be surprised.
yeah, but like the targets are different, in that case. But I mean, man, what a huge target! I mean, we're talking about $100+ billion for plaintiffs' lawyers to go after, and I have scruples and morals. Obviously, I like the fun of and excitement of high stakes litigation. There's obviously some plaintiffs' attorneys that might bring cases that are totally frivolous, but even that, just to tell everybody in general, again, when you hear what I'm saying, where the plaintiff's attorney has to advance all the costs of these cases, like the plaintiff's firm in the Ripple case, the civil case in Oakland, they're probably have already spent maybe $250,000, probably even more. They maybe spent up to $1 million of their own money that if they lose the case, that firm is just out $1 million. They just lost it. And so it really is hard. I mean, it's something that corporate defendants, it's a narrative they try and push out there. It's just terrible to bring a frivolous case if you're a plaintiff's attorney, because you've got to put so much money into it. If it's frivolous, you are going to take a huge business loss if you lose your frivolous case. So why do it in the first place?
Yeah, that makes sense to me. Yeah, no, it's really hard for me to look at Judge Torres and Judge Netburn going through this entire thing and coming out with the opinion that XRP, regardless of the status of anything, I mean, they must understand that they're going to, with what you just said, create havoc everywhere if they do end up saying that XRP was a security. And then if you just look at the facts like we've been talking about,